mediation certainly has its advantages, and Sarah has highlighted some of those. It can certainly help in reduce the backlog of cases in courts. But the reality is that it doesn't work in all cases. And I'll just kind of set out some examples of cases in which mediation will probably not result in a settlement between the disputing parties. So one example is that when the parties are so angry and just so reluctant to even sit in the same room with each other, and there's so much conflict and so much history between them, that it might just be impossible to get them into in the same room or agree to even try and settle a dispute. Now, there's certain ways around that. You know, there's what we call using shuttle mediation, put them in separate rooms, have a go-between, and perhaps encourage them that this is their moment to get things off their chest, because a party in court doesn't get to speak. It's the lawyers that speak. So sometimes telling a party that, look, this is your opportunity to speak, to get things off your chest, to scream if you need to shout if you need to, but perhaps then take it to something of a positive conclusion. And that sometimes attracts parties. They say, okay, well, yeah, okay, I'll speak. I'll tell the other side what my grievance is and my issue is. But ultimately, in certain disputes, parties just do not want to engage, and they want their day in court, and they want a decision that they can hold in their hand that they can then perhaps go and enforce. So that's one type of dispute where there's a lot of animosity, that the parties are just unwilling to engage in mediation. Another is where there's perhaps a complex question of law that's involved. Mediation tends to be the parties coming together and solving their factual disputes. They give and they take a little bit, and they try and reach some sort of middle ground. But if there is a complex question of law that needs to be interpreted, then that ultimately will be for a judge or perhaps an arbitrator to do. And that cannot happen in mediation. The parties will not sit down and agree on the interpretation of a particular provision of a statute. It's not going to happen. So in certain cases where there's a fundamental difference between the parties as to a question of law, then those sorts of cases also will perhaps not be suitable for mediation and may need to go down the court process. Then there are certain disputes where perhaps are very document-heavy disputes. You know, there's pages and pages of correspondence between the parties. There's lengthy contracts, which, again, in a mediation setting, may be difficult to kind of go through all of that and hash out kind of what the real issues are. But again, sometimes you can condense a very document-heavy dispute into certain core issues between the parties, and sometimes a skillful mediator could kind of boil down a very document-heavy case into certain fundamental issues, and it could be possible. But generally that may need to go to court and be resolved through a court process. Sometimes the veracity of documents need to be determined, you know, what was said, and how to interpret what was said by a particular party in a document. Then there are cases in which one party may be seeking some sort of injunctive relief, what we call in colloquial terms a stay order in Pakistan. And that, of course, the party will need to go to court, and that's unlikely to go to a mediation setting. They'll need the court's protection. So those sorts of cases also not possible to solve those in mediation. But one of the things from my own personal experience that I've recently noticed in the Islamabad High Court, that parties, especially in commercial disputes, are being encouraged to explore mediation prior to the court case proceeding. And the judge at one point remarked that I will pass adverse costs orders against a party which unreasonably refuses mediation. And this was a very long-standing shareholder dispute with families involved. multiple settlement agreements had already been signed and breached. And so that puts a lawyer and a party in a difficult position, because on the one hand, they don't want to go into mediation. They don't think that that's going to be going to bear any fruit. But they have this threat that if they unreasonably say no, then they might be lumbered with a heavy indemnity costs order by the court. So sometimes now parties are having to explore mediation because of this threat by the court. I wouldn't say a threat, but at least a reminder by the court that a costs order could be imposed. That may be good in certain instances, and we go back to the previous panel of how to reduce cases in court, and that could be worthwhile. But it also, in certain disputes, it may not be suitable. So the courts, I think, have to be mindful that certain types of cases perhaps mediation will not work.